Well, from Blevins Franks, I welcome back Cathal Rochford. It's been a while. How are you doing, Cathal?
Yes, indeed, Howard. It's been a while since we spoke. I'm keeping well. I'm glad that the new year's off to a good start. In fact, we're already well into the new year. So, how are you keeping yourself?
Yeah, I'm enjoying 2025, I have to say.
Me too.
So this week and next week, we're going to look at the estate planning considerations of British expatriates in Spain. Estate planning is not a pleasant task, but what happens if someone keeps putting the task off? What are the risks, and is having a will enough?
Yes, Howard. So as we get older, we tend to think more about our legacy and how it will pass to our family. You should already have a suitable will in place, but effective estate planning is about much more than just having a valid will, especially for expatriates who've moved to Spain or abroad. You want to ensure that your wealth is transferred to your chosen beneficiaries or your family in a timely and efficient manner without large inheritance tax bills or succession tax bills. Your estate plan needs to take account of tax and succession laws in both the UK and Spain, and also more complex families such as second marriages or children from a previous relationship. These require particularly strategic advanced planning. So when it comes to estate planning, in my view, the longer you leave it, the more expensive it becomes. And so effective estate planning can present a huge opportunity to reduce tax, preserve your hard-earned wealth, simplify matters greatly in terms of your assets when they pass down to the next generation. And if estate planning is not done right, it can present a major and costly problem if it's not been planned. So I would say, it's very important to have, a strategic estate plan in place earlier than later.
Some of our listeners will have set up an estate plan in the UK in the past. How important is it to revise it once they're living in Spain? And are the two succession regimes very different?
Yes, indeed. Family estate planning becomes even more imperative when you move to Spain from the UK, for example. The Spanish inheritance tax regime imposes forced heirship and a complex succession tax system. British expatriates may also have UK inheritance tax to contend with if they have not broken their long-term residency with the UK, or if they hold significant UK assets. Both taxes across the UK and Spain are very different, and specialist qualified planning covering both sides of the equation is crucial. Succession tax can be as high as 80%, and UK inheritance tax is charged usually at 40%. So with the right long-term strategic planning, both taxes can be largely mitigated, and often they can be avoided entirely. So it's very important to review both sides of the equation and make sure that you're not leaving one side out, and have an advisor who can cover both Spain and the UK on an integrated basis.
Can you explain more about Spain's succession law? Is it easy to get around it?
Yeah, so in Spain, like in France and some other European countries, we have what's called forced heirship, which is an old Napoleonic code that imposes, heirship rules to protect the bloodline so that children have more rights and a higher share of an estate versus a spouse, for example. So in Spain, this means that 2/3 of one's estate will pass to your children, and 1/3 can pass to your spouse. So this is actually very normal in Spain, and it's quite acceptable across Spain. So if you speak to Spanish people, this is what they're used to, and they're quite happy with that. However, for many British nationals, they generally prefer to leave their assets to their spouse, and the estate would then pass down to the next generation on second death. And so it is a change that you have to contend with. You can, however, use the European Succession Regulation Brussels 4 to opt for the succession law in your country of nationality to apply in your death instead. So you must specifically state this in your will, otherwise distributions of your estate will follow the law of your country of residence. So succession law is a little bit more complicated than UK nationals may be used to, but the good news is that if you're not a Spanish national and you're coming from the UK, for example, you can avoid forced heirship and these kind of Spanish succession laws that otherwise would apply, without having your will adjusted accordingly.
And before we finish today, let's look at wills. Should British expatriates living here have a UK will or a Spanish will?
It's advisable to make a Spanish will to deal with your Spanish assets, since it's easier to wind up an estate using a local will. If you only have a UK will, it would need to go through the UK probate process, inevitably creating long delays and higher costs, as well as having to get it notarized and translated officially before it being accepted in Spain. In any case, you may wish to update your will to make the election for UK succession law to apply to your estate when you pass. You can have two wills, one for Spain and one for the UK if you retain assets there. If you make a Spanish will and subsequently change your UK will, it's very important to make sure your solicitor does not inadvertently revoke your Spanish will. I think in a nutshell, it's best to have a will in each country where you hold assets. So if you've got assets in the UK, a UK will should administer for those assets. Likewise, if you've assets in Spain or France, you should have a will in each country. And this just prevents complexity and contradiction or cross-referencing across the various wills and your asset bases. And really that makes things more simple and efficient.
We're slowly inching closer to spring, and Blevins Franks often has seminars in the spring. Are there any plans for spring this year?
Yes, we'll be having a few seminars this year. The first one will be on the Costa Blanca at the Marriott Hotel in Denia on the 11th of March. My colleague Brett Hansen, who listeners know from these discussions, is presenting it. He will be looking at how the latest changes in Spain and the UK will impact British expatriates. These include the UK inheritance tax and pension reforms, the end of the golden visa here in Spain, and the potential Spanish high property tax for non-EU buyers. For our listeners further afield, we will be having seminars covering whether it's time to rethink your UK assets in the Canary Islands on the 17th and 20th of March. We'll then have a few more events later in spring, and I'll be holding a seminar in Mallorca in late April. For more information and online booking, and I would say they're very well worth attending. There's lots of valuable information and insights provided. Please visit our website on blevinsfranks.com.
Cathal will be back next week to continue our estate planning discussion. We'll be looking at inheritance taxes, Spanish succession tax, and UK inheritance tax. I look forward to it.
Thank you very much, Howard. I look forward to speaking next time.